How can I? Oh, I haven't let anybody in yet. Manage participants, admit all. Okay, let's admit Sebastian first. Hey, Sebastian, you there?
I am, Judge. Can you hear me, Judge? Can you hear me?
Yeah, yep. Okay, test, test, test. So we should be live on YouTube at this point. We do have an open courtroom just in case. So have you looked at everybody that's on the list?
I don't know what you mean by that. I got a couple of emails back when I sent out the deletion and said you're sending out a new notice. So 2 people answered, but I see you mean on the participant list?
Yeah, let's just we can admit all. Let's just make sure we have everybody.
I don't know I have access to any of that anymore. I just see me and you.
Okay, then I'm going to admit everybody, and then you should be able to see everybody.
All right. And you actually show up twice, by the way. So I'm not sure if that's going to cause some issues, but you are there twice.
I'm going to try to change that.
Morning, afternoon.
Good morning.
Hello.
Hey.
Good morning.
Good morning.
Good morning.
All right, we're just going to take a minute and get everybody on here. I'm on here twice. I'm trying to remove myself. I hope I don't do something wrong when I push this button here in just a second. Might not. Well. I'm putting my other self in the waiting room, so hopefully that will get me off the screen. We are definitely still figuring all this out. Thank you everyone for being here. Let's just check and see if we are missing anyone. Sebastian, can you look at our participant list and see if everybody appears to be with us?
I will. I'll run down the list and I'll let you know in a second, because I'm gonna have to kind of cross them off. You know, it's about 8 or 10 people on here. So give me 1 sec, Judge, if you don't mind.
Sure.
Don't see Warner Fox. I don't know if someone is appearing for Mr. Fox or.
I am, Warner and I work together. He's my partner.
Okay.
So he won't be appearing.
And is JES, is that James Sessinger?
Yes, that's me.
So you're here from, all right, Judge, as far as I can tell, that was the only one absent, and they have someone appearing for them. So I think everyone's here. You're muted, Judge.
Okay, I'm trying to use correct Zoom behavior and mute myself if I'm not speaking. Welcome to our hearing. We are still getting accustomed to doing this and are still trying to figure out a few buttons to push. I know you have probably all participated in more of these than we have at this point. Part of our issue is dealing with government technology, which you would think it might be a little more cooperative given the state of affairs of our nation, but we're a little lagging in some of our technology here, so that makes things a little more difficult. Bear with us. I've been running back and forth between the courtroom here and my office and not knowing where we were going to do this from, but we are actually sitting in a courtroom. My court reporter, Nancy Fiermonte, is here with us. I am going to step off for just a second and go grab some things from my office that I need for the hearing, and then I'll be back with you. If you can, while I
Looks like she froze. Is anyone else hearing her? Okay,
I'm not.
I'll go tell her. Hold on, I'll go tell her.
That's not a good sign that we've lost the judge.
No, it's not, is it?
But I was thinking of all the times in my career I wanted to freeze a judge. Just this was not one of them.
Well, the good news is that her other box was in the other room, so she could move that one back in here. The fact that we all didn't go off is a good sign.
Okay, so the judge's computer in the courtroom crashed, totally froze. So she's going to get her camera and stuff and move it into her chambers. And the court reporter is going to come with her. So if y'all just give us a minute, we're going to reset up in her chambers and we're going to broadcast from there. So just please hang tight if y'all don't mind. Thank you.
It's Kurt. How are things going in South Carolina?
Going well. Back on the golf course now for a few minutes while we wait on the judge.
Love it.
No, I was actually supposed to play golf this afternoon and it's going to rain.
Yeah, you know, it looks like it's going to rain here too. So if you're going to go on the golf course, then I'm going to do this. This is where I am.
Yeah, you just hope you're going to be there this fall.
You're darn right I do. I have my hopes. I have my hopes. We'll see.
I haven't seen you do an at-home senior prom yet. Is that coming?
You know, we're not doing an at-home senior prom. In fact, they rescheduled it, I think, for the fall. I can't remember the date. So they're going to try to have one. It's just going to be weird because everybody's going to be in college. Then what do you do?
Right.
So, but actually we're going to do we're going to surprise her and do some sort of celebration kind of fake graduation ceremony at the house. We're going to do something like that.
Did I see she signed to play soccer at Georgia?
Yes.
That's
Yeah.
awesome. Congratulations.
If they play soccer, right?
If they play it right. Just gives her a reason to stay an extra year.
That's right. Well, I know they're giving the folks from the spring, they all get an extra year of eligibility. I don't know if they're doing that for fall sports.
Yeah, well, if they
Maybe.
don't,
We might get there.
if they don't play football and they don't play the NCAA basketball tournament, there's not gonna be money for any other sports.
Very true. Very, very true.
So I know the NCAA has another year of eligibility for the spring sports, but what are the universities doing? Are they giving another full year scholarship?
I think they're trying to figure out what money they have. Truly, because I think some of them are really struggling with, what do you do with a baseball team with 15 scholarships and having those guys stay another year?
Yeah, like I said, you got lots of things.
I think they're doing it by institution because I know the University of Georgia announced that they're going to honor all those scholarships. I don't know if other schools can do that or will do that.
My son's school's doing that, and they give him a 5th year of eligibility.
Yeah.
And he runs track, which is a spring sport.
What school is that?
Georgetown.
Oh, yeah.
They run on top of the field house, don't they?
I'm not. No. What?
Oh, I thought that. Yeah, Georgetown's track used to sit on top of their field house. I ran track at Virginia. I was a little thinner then, and we used to run at Georgetown on the roof of the field house.
I haven't seen that, Kurt.
Kurt, now all these years I've known you, I didn't know you ran track.
Well, there are little things that you got to
Did I
keep.
know
stuff
that and
secret.
forget it?
What's
What were
that?
your events, Kurt?
I ran the 800 meters and the 400-meter hurdles.
Oh, wow.
And every year I go out and set up one hurdle at 36 inches to see if I can still get over it. And I will say, at least at 52, I can still get over a hurdle, but I can only get over one.
Nice.
Be great.
Do you get a running start first?
Oh, yeah. It's more like a high jump now.
I can see they're still on.
Okay. Everybody still with us?
I believe so.
Y'all are all muted, so. Manage participants. Okay, can everybody hear me? Okay, y'all are all muted right now, but what I'm going to ask you to do is one by one, if you will introduce yourself and who it is that you represent. Our court reporter is going to make a chart really quickly. This is on a large screen right in front of her. At least it will be in just a second.
Yeah, is Odyssey still causing trouble? Cool. Yay. Yeah, mine's
All
up
right.
again, but it crashed a minute ago.
We have our click share working, Sebastian. So let me make this larger. It looks like we have 15 participants. And let's try this again. This is when I step off to go grab what I need. And hopefully this will not freeze in the meantime. All right, I'll be right back. And if y'all will just go one by one, unmute yourself and tell Nancy who you are.
All right, I'll begin. I'm Darren Penn. I represent the plaintiffs in the case.
Chris Glover, also for plaintiffs in the case.
Hey, I'm sorry, you gotta give me a minute. Who's Mr. Penn?
I am Darren Penn.
Okay. Next.
Chris Glover, also for plaintiffs.
Okay.
Melody Glauton for the plaintiffs.
Melody, I don't see you on my list, so it's Melodie.
Melody
And your last name?
Glouton.
Okay. Next.
Also for the plaintiffs, Alexandra Sashi Cole.
Thank you.
Also for the plaintiffs, also for the plaintiffs, Kevin Kettner.
I don't see you on my list either. So Kevin, did you say?
Yes, ma'am.
Last name?
Kettner, it's Ketner.
Thank you. Next.
Jimmy Singer with Bovis, Kyle, Birch, and Medlin, one of the attorneys for Skyjack. But also.
James Singer, right?
Correct.
Thank you.
Teresa Warden-Benz, another attorney for Skyjack.
Teresa. I'm not seeing you on my list either. So spell your name for me.
Sure, it's Teresa, Teresa. Last name is Benz, Benz. But I am in this case, I think, previously as Warden, Wardon.
Okay, thank you.
Kurt Rozelski, also for Skyjack.
Anybody left?
Yes. Gilletta Smith for the plaintiffs.
I don't have you on my list either. So if you could spell your name for me.
Sure. Gilletta, Jalletta. Last name is Smith, Smith.
Okay, thank you. Did I get everything?
Willie Ellis for OEM Controls.
Okay, so I don't have you on my list. What did you say your name was?
Willie Ellis.
I have you. Thank you. So,
And one more, Andrew Capobianco for NES and Brian Stone.
thank you. So,
And I think I'm last. My name is Matthew McLaughlin. I represent Wheeland Electric.
12. Thank you. So just so that I can streamline a little bit the takedown fee, is there like one person for the plaintiff that I can send a bill to and one person for the defendant that I can send a bill to? I mean,
On behalf of the plaintiffs, you can send that bill to me, Darren Penn.
And for defendants, we have 4. I don't know what is easier for you, but you can send the Skyjack one to me, James Singer. That'd be fine.
Thank you. And I'm not going to be able to remember all your names if you are all speaking. So if you would just please give me your name before you start talking. Thank you.
All right, we are, I believe, ready to begin. And it does appear at this point that everything is working well. I'm going to let our deputy, who was kind enough to come and open our courtroom, know that we actually do have this working on live streaming. So you can go ahead and close the courtroom and go back to other matters. Thank you for coming up here so quickly. Appreciate it. Have a good afternoon. So we do have a live stream set up on YouTube, and the link is published on our Gwinnett Court's website under my individual page for Division 3. And so anybody that wants to watch can go on there and watch the proceeding. And so we are in compliance with open courtroom rules. At this point, I'm not sure if there's a preference among all of you on which issue you'd like to hear first. Maybe we should go with the motion to substitute first and then move on from there. But I'm willing to go in any order if y'all have a preference.
Your Honor, this is Darren Penn. On behalf of the plaintiffs, I think that's probably the best way to go. I think we need to take care of this motion to substitute the plaintiff. And I think largely on the issue related to the confidentiality order, I think we have most of those issues worked out and we're down to just the sharing provision, I think. Maybe we can get some more clarity when we get to that. But I think it makes more sense to get into the motion to substitute the plaintiff.
Okay, is everybody okay with starting that way?
Yes.
Judge,
Yeah, hold on. The court reporter has a question. Hold on. Yes.
I'm not on.
You're not on. Okay, give us just a minute.
I clicked out when I thought I was moving.
So how many of you ever thought when you went to law school you'd wind up having court like this?
I certainly didn't.
But I did think we'd have flying cars by now.
Okay. Aren't those called helicopters?
Yes, they
I
are.
saw where they have a service somewhere in New York or California or somewhere where the helicopter picks you up at your house or near your house and takes you to the, I don't know, the nearest heliport, whatever those are called, to your office. That would be fun.
Yeah, it would. It'd be a lot of fun.
All right, Nancy, are you good?
Yes, sorry.
Okay. All right, we are ready, Mr. Penn.
All right, thank you, Your Honor. And just by way of introduction, my name is Darren Penn. I represent the plaintiffs in this case. And I'll introduce the other folks on the plaintiffs team who are joining us this afternoon. Chris Glover is our co-counsel, and he's with the firm Beasley Allen. Sashi Cole and Kevin Kettner are with my office and working on this case. And then I also asked to join us today, Your Honor, Ms. Melody Glauton and Gilletta Smith. They handled primarily all of the issues that relate to the probate court matters and actually the latest order and finding where Joanne Taylor has been appointed the permanent guardian and permanent conservator for Ms. Mahala Moyes, who was the named plaintiff in the case. So I asked them to join us today in case any questions come up related to the probate court filings. And so they're here to answer any of those questions as they may come up. But just to give the court kind of an overview of the tortured history of this case, it was originally filed back in May of 2015, and we filed it in the state court of DeKalb County against a number of defendants, all of whom are here to represented here today. That was Skyjack, who is the manufacturer of the scissor lift that's involved in the case, and you have OEM Controls, which manufactured the control box for the scissor lift. Wheelan Electric, which provided electrical components that go in that box and have to do with the joystick and the operations of the joystick. And then you have NES Rentals, which rented the scissor lift to Southern Mechanical Contractors for the Chamblee High School project, what the scissor lift was being used on. Then you have Mr. Stone, who was the manager out at NES Rentals. So what happened is, after we filed this case in May of 2015 in DeKalb County, it was quickly in June removed to the Northern District of Georgia. Long story short there, that case, it was ultimately remanded back to the state court of DeKalb County. And it was determined that Mr. Stone, who was our supposed venue defendant in DeKalb County, actually lived in Gwinnett County. And that's why this case is now pending before you, Your Honor. We ultimately transferred the case here in Gwinnett County, which is the appropriate venue. And that's what brought us here in April of 2016. Shortly after, within about a couple of months after the case was transferred here, there began to be some problems as far as discovery was concerned, and as far as some of the estate issues were being worked out on behalf of Mr. Moise's estate. And just to very quickly kind of remind the court what the case is all about, is Mr. Moise was a plumber. He was working at the Chamblee High School project. He was brazing a pipe in an area of the gym. He was using the scissor lift to kind of get himself up to the height of the pipe. And there was a malfunction with the joystick. As he was leaning over to braze this pipe, he contacted the joystick. It raised the scissor lift. He's pinned against the pipe, and he suffered burns and compression asphyxia, and ultimately died as a result of that incident. Case was brought against all of these manufacturers on product liability theories, and that's what brings us before the court. Shortly after the case was transferred here to Gwinnett County, the estate issues kind of began to raise their head, and the parties jointly filed a motion to stay discovery back in June of 2016, so we could get all of these issues worked out. The court granted that motion on June 24th. And I'm going to jump forward because a number of months went by. Ultimately, Joanne Taylor was appointed the administrator of the estate for Mr. Moise on December 16th of 2016. Shortly after that, actually not really shortly, because we're still working through issues as far as wrongful death representation, but in April of 2017, April 5th, that's when we, on behalf of the plaintiffs, filed our original motion to substitute the parties. And we asked the court to substitute Ms. Joanne Taylor in as both the representative of the estate as well as the representative to bring the wrongful death claims. That motion was granted. There was an order issued. And as the court is aware, ultimately there was an objection from the defendants. We end up with a certificate of immediate review, and we go off to the Court of Appeals for a number of months where those issues were heard. And really the big complaint there was that Ms. Joanne Taylor, as the administrator of the estate, was not necessarily the proper party to also be the plaintiff on the wrongful death claims. We got some guidance from the Court of Appeals. They ultimately ruled that under these circumstances, under these factual circumstances, there was no clear evidence that Ms. Moyse had ever been deemed legally incompetent. And as the court is aware, all persons are presumed to be competent until they are proven otherwise, and there has to be an actual legal finding of incompetency. Well, that didn't exist in the record, and the Court of Appeals pointed that out and said because there was no evidence in the record that she had been deemed legally incompetent, they reversed that part of the order that allowed Ms. Joanne Taylor to be the plaintiff on the wrongful death claims. So after that happened, a number of things happened in the probate court of Gwinnett County. Petitions were filed. Specifically, a petition was ultimately filed. And I'll go ahead and let the court know this. I think it's pertinent. I think it's something that you should know is that in the interim, while all of this was going on, one of Mr. Moyse's sons, Daniel Moyse, reached the age of majority and became a legal adult in Georgia, 18 years old. There were multiple discussions involving Mr. Moyse as to whether it would be appropriate for him to file a petition to be a conservator and or guardian of his mother. Ultimately, at the end of the day, it was decided that Ms. Joanne Taylor would file that petition, and that's exactly what happened. There was evidence that was gathered before the Gwinnett County Probate Court. Ultimately, there was a hearing, and at that hearing, the number of witnesses testified, including representatives from the state and other representatives involved in that probate court hearing on July 9th of 2019, the Gwinnett County Probate Court entered a final order. And in that final order, the court determined that Mahala Moyse was legally incompetent and was not able to handle her affairs. And in addition to that, not able to handle her property as well. So Joanne Taylor was appointed as the permanent guardian and the permanent conservator over Ms. Mahala Moyse on that day, on July 9th, 2019. Following that, we filed our second motion to substitute the party plaintiff. And just kind of back up to the Court of Appeals, the substitution of Ms. Taylor as the plaintiff on behalf of the estate was affirmed and not set aside. That was a proper appointment at the time that it was made, at the time the court made this. And now all we're talking about is who is going to be the proper party plaintiff for the wrongful death claims. And in order to do that, you have to have somebody as a guardian and a conservator over Ms. Moyse, because Ms. Moyse is living, she's alive, she's healthy, physically healthy. And in those circumstances, we're not in a situation where the person to be the representative does not exist. We have the person that could be the representative. They're just legally incompetent. In that scenario, you have a guardian, you have a conservator appointed. That's exactly what's happened with Ms. Joanne Taylor. And now she's the appropriate party to step into Ms. Moyse's shoes on behalf of the wrongful death claim. And that's the basis of our motion. I know the defense, we've kind of had a tortured history on this motion. And I will just add this, that Ms. Moyse, as we speak today, is in a state mental health facility where she resides 24 hours a day, 7 days a week. And there are no plans to release her. In fact, that, you know, I'll just reiterate again, the Gwinnett County Probate Court found that she is permanently legally incompetent due to her mental condition. So the defense, to kind of add to the tortured history that we're dealing with here, for some reason, we've reached out multiple times to the defense to try to get a consent, to try to get agreement to just substitute this party and let's move this case forward. You know, here we are. Literally, it's one of the oldest cases I'm working on. And here we sit, and we're still not even into any of the real fact discovery as it relates to this product. So many years later, and we're still fighting about who should be the proper plaintiff. We've reached out multiple times to try to get consent. They've refused to do it. And in my understanding of reading their response brief, they are attempting to switch the burden of proof onto the plaintiff to prove a point in time when Ms. Moyse was competent or not competent. And it's really, that's absolutely wrong. The burden of proof is on the party that's trying to establish the incompetency of that party. And Georgia law is very, very, very clear. You are presumed to be competent until found otherwise legally. We have one order in this case. There's actually there's a criminal order from, I believe, 2018, where Ms. Moyse was found incompetent to be able to stand trial on criminal charges pending against her. Although it was cited by our probate court, there was not a specific finding that she's legally incompetent as a matter of law to be able to pursue other legal matters on her behalf, but she was not competent to be able to stand trial. We have that order in the July 9th, 19 order. We have a specific finding after a hearing about specifically her competency. And we can even back up to the 2018 order if we wanted to, but I think it's very simple for the court. I think it's very straightforward. She has a guardian, she has a conservator. That's the person that needs to be the plaintiff for the wrongful death claims. And it makes all the sense in the world because she just happens to be the administrator and the plaintiff on behalf of the estate. So that's the basis of our motion. If you have any questions, or if there's any other information that Ms. Smith or Ms. Glaughton could add or to maybe help, I'm happy to have them fill in some of that. But we think it's very straightforward, and the motion should be granted.
Ms. Smith or Ms. Glaughton, do you have anything else that you'd like to add at this point on this subject?
The only thing I would add on this subject at this point, Your Honor, is that even if the court looked to the 2018 criminal matter and looked at the competency in 2018, the complaint in this matter was filed in 2015. So that determination occurred 3 years later. And under the conservator statutes, which is 29-5-1, the finding of incompetence to stand trial is not sufficient to establish the need for a conservator or guardian. So even if the court looked at 2018, we have the problem of that being 3 years after this complaint was filed. And in addition, under our statutory scheme, that finding alone is not enough to establish whether Ms. Moyse was incompetent in 2018. The other thing I would emphasize is that there were a number of years that passed after the complaint was filed before there was any finding of incompetency. And she is presumed incompetent until found to be incompetent, until found otherwise by a court. So if we go back to 2015, and somehow the court were to reach back that far and determine that there were issues surrounding her competency, that wouldn't mean anything other than her complaint could have been voidable at that time if her guardian didn't pursue it. Her guardian and conservator is ready and willing to step in to pursue it. So that is the proper party plaintiff at this point. And unless the court has any other questions on the guardianship procedure, that's the only thing I would add.
Thank you. Ms. Gloughton, did you have anything?
Thank you, Judge. The only thing I would add, and it would just be to clarify some information that Mr. Penn provided, and it sort of highlights the egregious nature of this case. Mr. Penn indicated that, in fact, Ms. Moyes does have a son that became 18 in the process of this case pending, and that, in fact, is true. I was the one that helped with the underlying guardianship and conservatorship in this matter. And just to clarify, Ms. Taylor is actually appointed as the conservator. Unfortunately, Ms. Moyes has the guardian of last resort that we refer to in the state. Her guardian is the Department of Health and Human Services, and that is why we are requesting that Ms. Taylor be appointed as the conservator and the one to proceed with this particular case. So I think that really highlights just how terrible this case is and how unfortunate the circumstances are surrounding this. And to be quite frank, it's unclear to me why this is still even an issue in this case. There's no question that Ms. Taylor should in fact be the one to proceed with this. It's unclear why this wasn't stipulated to by the defendants in this case. They tried in probate court to obtain access to her medical records, which that is, they have no interest in gaining access to those records. And if you look at the facts that surround this particular case, we have 2 children that are effectively orphaned as a result of this case. And I think that it's time to litigate the merits and move forward.
Thank you.
Thank you.
All right, response?
Your Honor, this is Willie Ellis. I'm going to just take up, I guess, the first part of this. So the clear reason why this is being done, Your Honor, is because it's one of standing. If there is an improper party bringing a case from the inception, then the court does not have subject matter jurisdiction. And that also affects us as defendants, because if I wanted, for example, my client wanted to settle their portion of this case out, they would not be able to rest, because if we later find out that Ms. Moyes was not competent when she retained counsel, then another party, either their son or someone else, could bring a lawsuit years later and say, well, we don't like what was done there. She wasn't a proper party. Whoever counsel she hired was not hired properly, and therefore the settlement would be no good. And it would be the same thing for the court. If this matter were to go through trial, and we later find out the court didn't have subject matter jurisdiction because this was not handled properly, then the judgment would be void. So it's not a matter of making a mounting of a molehill. This is a molehill that needs to be addressed. All the documents that would satisfy our clients and probably the court are in the plaintiff's custody. They've been following them with probate court. They have them in their own custody. They have not, but they refuse to turn it over and ask for us just to trust them. And that's improper under these circumstances. And so I'm going to also give the court a little bit more background that was not addressed with plaintiff's opening. I'm going to try to share my screen. I'm new to this. I'm really trying to get this, but I have a couple of things I think will illustrate the point. So just give me 1 second, Your Honor. Can you see that?
Yes.
All right. This is a timeline, just a brief timeline. I'm going to show some documents as well. But The incident happened on May 7, 2013. I don't know what just happened there. Is it frozen on your screen as well?
Yes, I can see your cursor moving, and then I see a cursor flashing down in the middle right-hand box.
Okay, let me just try this again by restarting the program. Okay. Okay. According to plaintiff's filings, they have suggested that Ms. Moes exhibited clear signs of being mentally unwell immediately after her husband's death, which occurred in 2013, which resulted in Gwinnett County Child and Family Services removing Samuel and Daniel from her care and placing them in foster care. Ms. Moes was subsequently arrested and incarcerated, and she was diagnosed with schizophrenia, bipolar disorder, and psychotic disorder. This is not our statement. We took this statement from, this is plaintiff's appellate submission to the Court of Appeals on November 13, 2017. In plaintiff's brief, they wrote, Mr. Moes' death caused his wife, Ms. Moes, to have a psychotic break, resulting in Gwinnett County entering their home, removing their sons, and putting them in foster care. They continue on and explain that this happened immediately after Mr. Moes' death, and during the civil litigation, Ms. Moes exhibited clear signs of being mentally unwell. Her mental instability resulted in Gwinnett County taking her children. And so that is from the plaintiff's own submission that in 2013, she was already showing signs of being unable to take care of her affairs, and that she had some diagnoses of bipolar, schizophrenia, et cetera. That bears out even in documents that we were able to publicly get. We can't get all these documents, and we can't get into the mental health of these documents. But as defendants, we had to scour these documents. And let me back up, Your Honor. So when this case was first filed in May of 2017, the defendants had no idea there was anything wrong with Ms. Moes. It wasn't until we served discovery in 2016 that we were first told there was something wrong with Ms. Moes. When we served discovery and we were asking for responses to our interrogatories and document requests, that's when we were first told we can't get those because they have no one to provide responses. We were confused by that. And we were first then told that, well, Ms. Moes has lost her mind. That was the explanation we were provided by plaintiff's counsel. That's what resulted in the stay that plaintiff's counsel talking about, because we wanted to take her deposition and find out what he means by Ms. Moes has lost her mind. We wanted to also get our discovery request. At the same time, plaintiff's counsel, they were propounding discovery to the defendant parties, and we were not going to answer discovery when our own discovery had not been answered. And so we agreed to a consent order to say discovery. That's how that happened. So again, let's go back to some of the documents we were able, after our own diligent research, that were publicly available. This is an order from 2014, September 2014, Gwinnett County State Court, where there was a petition granted for a psychiatric evaluation of Ms. Moes. This is a little bit more of the forensic evaluation review. This is a part of the same 2014 document. Can you see that? I can blow it up a little bit.
Yes.
Okay. And it says here that, her charges were contribute to the deprivation of 2 children. And it says here at the bottom, she has been treated previously, unaware of the result of any ongoing treatment. We don't know either. The next page, it goes on to say that they were going to have this referral to determine whether or not she's competent to stand trial. But it goes on to say that she's unable to communicate about the facts relevant to her defense. She has unrealistic expectations of life and impossible delusions. Again, this is 2014. There are other documents that went along with this that we can't get access to, but the plaintiffs can. They probably already have it. There could have been determinations as to how unrealistic her expectations of life are. How impossible are her delusions? We don't know. What we also know is on March 9, 2015, a little less than 2 months before this lawsuit was filed, there was an order by the Gwinnett County Court for mental evaluation. And again, some of those things they want to know is whether or not she can comprehend her own condition, whether she suffers from mental disorders that impair her and the extent she's able to cooperate in her defense, whether or not she has a mental capacity to distinguish between right and wrong. A Gwinnett County judge was convinced this was required 2 months before this lawsuit was filed. Again, Your Honor, we don't have access to the results of this and what the determination was. So this is not a typical lawsuit where you can presume that a person is competent until proven otherwise. There is clear evidence here that Ms. Moez suffered incompetency immediately after her husband's death in 2013. And these are statements made by her attorneys and they're documents that we had to go find on our own, but we cannot get the extent of that file. So what we're talking about here, and the reason why you object, going back to standing, is that plaintiff has the ability and has submitted themselves to the jurisdiction of this court, but they have the ability to establish the timing of when Ms. Moez became incompetent. And the lack of clarity in this could easily be cleared up by plaintiffs, but they refuse to do so to us. They would do it to the probate court, and I think they would do it to you, Your Honor, if they had to. And that's up to your court's power for you to do that. And the reason why it's important is for going back to the issues of standing. If it's later determined or raised by an heir or raised by another interested party that Ms. Moez did not have the ability or mental capacity to hire legal counsel in this case, then everything that's happened since cannot be ratified. It's not voidable, it's void. Any judgment is void. Any settlement leaves all my clients, all the people, all the defendants on this tape, on this video, subject to future legal action on something that could be settled and handled right now by plaintiffs. And they have avoided doing so because mental health records, as you know, have some of the highest protection available under Georgia law. It has to be given, and they have the party that can waive those records. They now have a conservator who can waive those records and can give those documents to them, to the lawyers who actually prepared this. I think 2 of them here on the call with us, and they can give it to the court. And all we're asking, all we've ever asked was we believe and have good reason to believe that she may have been incompetent. Can you just show us that she was not at the time that she filed this lawsuit, at the time she hired legal counsel? So plaintiffs rely on, I think, OCGA 91125 that says if a party becomes incompetent, the court may allow an action to be continued to by or against the representative. But if you read the federal interpretation of Rule 25, it clearly states that incompetency must arise during the suit, not before the action is commenced. We cited that in one of our documents, and the case site that I'll give you right now is Bob versus Washington Metro Area Transit Authority. That is a District of Maryland case, and it can be found at 2015 Westlaw 6460082. But it makes sense that competency is the general thing that allows a person to read a complaint and determine whether the allegations alleged in there are true. It is also the things that allow a person the mental ability to hire counsel and make that decision. And so we're not attempting to shift the burden of proof here. We had evidence here that Ms. Moes, almost immediately after her husband's death, was incompetent. That's exactly what it says. There's also something that is interesting that also in plaintiff's brief, they wrote this to the Court of Appeals. They said, in the petition, plaintiff's counsel certified that since the filing of the complaint, the plaintiff has been unable to locate, otherwise communicate with Ms. Moyes. So since 2015, they're saying 5 years, they haven't even talked to her. I mean, that's my understanding of this statement. And that was actually given in a document. I don't have it here because of the limitations I have here. But in a document that the plaintiffs filed with the probate court, on August 8, 2016, Jeff Harris filed a petition for letters of administration in Gwinnett County Probate Court. In that petition, he states that he has no information regarding the present whereabouts of Ms. Moyes or her minor children. And so he moves for the appointment of a legal representative to substitute for Ms. Moyes so he can continue to protect her interests, as well as the interests of the children in the estate. He states that since the filing of the complaint, he has been able to communicate with her. And prior to her disappearance, all communication has been through a translator because I understand her native language is not English. And so I don't blame any attorneys or anyone on this phone call if they weren't able to discern whether or not Ms. Moyes was competent or whether she was coherent. Because if she was speaking to them through a translator in another language they didn't understand, they had no way to know that. But what we do have are documents, court documents showing there is a question that could be answered by the plaintiffs, and that has not been answered here. And it leaves all of us subject to future headaches for something that should be easy to deal with. In fact, in this same document, this is very telling. The plaintiffs moved and to filed a motion to supplement the appellate record. And the reason why they filed a motion to substitute the appellate record is because they said that they want to provide evidence under seal related to Ms. Moyes' legal competency to serve as the party plaintiff. Because this evidence did not exist in the trial court. And so because evidence didn't exist in the trial court record, they had to supplement it and give it to the Court of Appeals. There's no reason for it not to be the trial court's record because this trial court has to determine whether or not Ms. Moyes whether or not they're standing for this case to continue, whether it's subject matter jurisdiction. So if this has been given to the Court of Appeals, I don't see why it can't be given to this court. This is their motion to supplement the record. And again, it says, however, as it stands, the trial court record lacks necessary information regarding Ms. Moyes. This is not argument. I didn't show you one brief filed by defendants. These are all arguments taken directly from plaintiff's own filings. So what is the issue with providing this court or defendants an opportunity to see it so that we can go back to our clients and say, if we want to resolve this case, we know we have the right party to resolve it with. We know there's not an issue of standing. You have to worry about future actions later on. Why is it so difficult to provide this to the court? So the court knows it has subject matter jurisdiction and that we can move this case. This is not a situation that has been made by defendants alone, but defendants have asked for this information, and that's why we cannot just consent to it. I mean, even here, they kind of listed some of the information they need to give the Court of Appeals. They gave juvenile court transcripts since 2014. They gave them medical records showing she's legally incompetent. Well, what are those records? When were they dated? We don't know. The court doesn't know. Again, these are plaintiffs' own filings. So going back, Your Honor, we have, as defense counsel, done all we could to determine this information on our own. We even filed, like plaintiff pointed out, a petition to the probate court to get access to information. The probate court denied our motion, saying we're not interested parties. And that's fine. But we're interested parties in this case. We're interested party before this court. We have an interest in making sure that the right party is litigating this case, because otherwise it's just a waste of resources. If we go through this trial or we settle and we find out we did the wrong party, not only do we waste probably hundreds of thousands of dollars in attorney fees and costs, but we waste this court's time, because the judgment would be void. And so what we're asking, Your Honor, very simply is these things can be handled. Right now, the plaintiffs have the documents. They've never said they don't have it. The plaintiffs have access to the documents. They never say they don't have that. And they've just said, we're not giving it to defendants. You don't have a right to it. Fine. But Your Honor, you do. And you can ask, you have jurisdiction over this court, this claim. You have a right to know whether you have subject matter jurisdiction. And we believe that this court can, whether it can ask the probate court to give it its file, and you can watch and you can review the stuff in camera, or whether you can ask the plaintiffs to give you the documents, the same documents to get a court of appeals, or whatever other documents the court wants. So we can determine whether or not we have the proper party plaintiff. And then after that's done, I think we can move this case. And so we ask that the court deny the motion to substitute Ms. Taylor until there's be a proper showing. It's not a matter of shifting the burden. We have produced documents showing that there is a genuine issue, a genuine question of whether or not Ms. Moyes was competent to retain counsel, whether or not everything that's happened thus far has even been by her own will. As you've seen, they've made statements that haven't talked to her in 5 years. They saw her one time with a translator and then they haven't seen her since. And so with that being the case, that alone should cause a court pause and should allow us to get more information, at least the court get more information about whether or not there's whether or not the proper party before the court. I hate to keep beating the same horse because it's a very simple issue that can be solved by the plaintiffs, but I'm saying it in multiple ways so you can understand that this is a situation that can be remedied, and the party that can remedy it has all the documents and just refusing to do so. I don't have anything else to say on that. I rest.
Okay. Thank you. Thank you, Mr. Ellis. Mr. Penn, did you want to respond to that?
Absolutely, Your Honor, and thank you. First off, there's a number of things I want to follow up with, and Your Honor, I hate to say this, but we're getting literally into the point of frivolousness, and it's really, really, really beginning to be very aggravating. Here we are this far out. So I want to take a couple of things that Mr. Ellis just said. And oh, by the way, all of these things that he just brought up to the court, we have had face-to-face discussions about, and we have addressed multiple times in person. And he refuses to listen to anything that's been said to him. So first, with all this evidence that he's talking about, that he's bringing up in the record that they had to go and get independently, and that it's not in the record of this court, completely wrong. I will show you and I will share. Let me share. Let's see if I can share this. I think that's what I want. Can you see that, Your Honor?
Yes.
So this is a pleading from November 14, 2017, filed in this case, plaintiff's motion to supplement the record, where we filed in the record, Exhibit A is the I think it's the brief. Yeah, the appellate brief that we filed in the record here. Exhibit B is the transcript or the at least the face page of the transcript that he just talked about from 2014, Exhibit C are those medical records that he was talking about and spent so much time saying that they exhibited all of these signs of her legal incompetence. Jail records were Exhibit D. And then the June 24, 2016 order staying discovery, we supplemented that as Exhibit E. So all of the evidence he just talked to the court about was in the record of this court back in November of 2017. He talked about in 2013 that she exhibited signs of mental instability. Well, Your Honor, I hate to admit this, but anybody who knows me knows this is true, but I exhibit signs of mental illness probably every single day of my life, but that doesn't mean I'm legally incompetent and that I'm declared legally incompetent. Again, I will fall back on the case law that we have cited. In fact, the defendants cited this in their brief, Gulf Life Insurance Company versus Wilson, 123 Georgia Appeals 631. Mental or physical impairment is never presumed. It must be proven. And we have stated multiple times on the record, I will state it again on the record, there was never a finding of legal incompetence of Mihaela Moyes until arguably that criminal order, the order in the criminal proceedings back in 2018. And we cited to that in our brief, in our reply brief, and specifically in that order, here's what's telling. The judge in that court, in the criminal proceedings, found that she was incompetent to stand trial as of 2018, but specifically said this is a temporary incapacity. It's not permanent. There is no finding of legal incapacity and permanency until the order in 2019 that I talked about, July 9th of 2019. So the only other thing I want to talk about is Mr. Ellis began his comments to the court, his whole argument that this is about standing and all this hysteria about there's not going to be, if there were a settlement, that the heirs could come back and challenge the settlement. First of all, there are only two heirs involved in this entire case, and that's Daniel and Samuel Moyes. And they are both clients of mine. They are my clients. Along with their mother, Mihaela Moyes, who is a client of mine, along with Miss Joanne Taylor, the administrator of this estate, who is a client of mine, and also should be the plaintiff for the wrongful death claim, who is a client of mine. So there's not going to be any kind of finality issue to even be raised. And if there was, if everything that Mr. Ellis said, and let me back up a little bit. First of all, who's going to decide whether she was competent at some point in the past? Is that something that you're going to have to do, Your Honor? I don't think that's your place. I think they have to prove, they have to get an order or show some evidence that she was deemed legally incompetent at some point in the past that they want to try to use to upend this lawsuit. And they simply cannot do that because that evidence does not exist. But let's just assume, even if they are right, even if she was completely legally incompetent, she couldn't enter into a fee agreement, she couldn't file a lawsuit, even though she is the proper party to bring the wrongful death case, that she was incompetent to do so. You know what Georgia law tells us? Under 9330, OCGA 9330, persons laboring under a disability, it specifically says individuals who are legally incompetent because of intellectual disability or mental illness, who are such when the cause of action accrues, shall be entitled to the same time after their disability is removed to bring an action as is prescribed for other purpose. other persons. So if she has a mental disability and she's legally incompetent and therefore can't bring her case, she has a period of time until that disability is removed within which she can file that case and bring it forward. And the wrongful death statutes are pretty clear. The surviving spouse has the right to bring the claim. And so at the end of the day, even if they were right, it was stayed, whatever they want to argue about all of this, her capacity is stayed until we have a guardian and conservator, which we do as of 2019. And that, at the end of the day, this is a lot of arguing and a lot of filing and a lot of wasted months and wasted years in this case over something that should not be. This is pure and simple defendants trying to plaintiff shop. That's all this is about. I don't know if my co-counsel have anything else to add, but that's all I have in response. Your Honor.
I have just 2 quick points. Well, I will say 2, maybe 3 quick points. Your Honor, first, is my understanding that that motion that plaintiff showed you to supplement the file was filed under seal. So we don't know what those exhibits were. The 2000 motion. So we don't know what those exhibits were. Defendants don't. As far as the tolling is concerned, that doesn't have anything to do about when you file a lawsuit. You file a lawsuit and you don't have standing to do it. The tolling period doesn't have anything about it. We don't dispute, Your Honor, that there is someone out there who could have properly brought this lawsuit. It could have possibly been Ms. Moes at the time she hired Mr. Penn's firm. And so, but we don't know. We just don't know. And it's the position that we're in where we should be able to know this because we know this in most cases. And we have here a situation going back to 2013 where we know we had a person who was unstable, had mental issues, had children taken away from her because of mental issues. And we know ultimately the court in 2019, I guess she became a ward of the state because she was mentally unstable, such that all these years when she's bouncing in and out of the system because of her mental instability, eventually the state just took custody of her. But we don't know when that began. And if that began before this petition was filed and before she could retain counsel, then this court doesn't have subject matter jurisdiction. We're all at risk.
Again, in regards to
go ahead. Sorry.
In regards to the plaintiff's motion to supplement the record, the document was filed November 14th, 2017. And you're correct that there are parts of that are under seal. I just wanted to clarify that. All right, anything else as to this issue?
Your Honor, if I may, I just wanted to put on the record, I referred to the void versus voidable issue earlier. Case law on that is Georgia Power Company versus Roper, 201 Georgia, that's GA, 760. It's a 1947 case, so excuse some of the language references to insane persons or lunatics, but it does state that the contract of such a person is not absolutely void, but is voidable. And so again, a guardian or conservator could step in and continue to pursue that. The other thing I would like to point out is that the Court of Appeals already evaluated the evidence that has been pointed to here. And in footnote 3 of their appellate decision, which can be found at 346 GA App 26, at footnote 3, they go through the October 2014 through April 2017 jail records, showing that she had been an inmate. They go through mental health treatment. They go through most of what was discussed here. And they say that this is not sufficient to establish that she has been deemed incompetent. And that's because we have a legal proceeding for that. That proceeding occurred in 2019. So she is not presumed under any of this that has been brought out to be incompetent. And the Court of Appeals has already evaluated that and said, this is not sufficient to show incompetency. The other thing I would point out is that the cases cited in Skyjack's briefing, Levinson v. Oliver, James v. New York, all of those cases involved wards who had guardians appointed prior to the ward hiring legal counsel. Ms. Moyse did not have a guardian or conservator appointed prior to filing this complaint in 2015. So the idea that it's void instead of voidable rises from someone who has already been deemed incompetent and already has a guardian or conservator appointed. Ms. Moyse did not. Finally, on standing, the court has heard this a couple of different ways, but OCGA 51-4-2, subsection A, sets out that the surviving spouse holds the wrongful death claim. We do have case law in Georgia, like home insurance versus Wynn, which can be found at 229 GA App 220, stating that a surviving spouse settles the tort claim on behalf of the children if the children are alive, and she can do so without the children concurring. So this idea that there's some kind of standing question here about who is entitled to bring this type of claim, it's just not borne out by the statutory scheme, which provides for the surviving spouse first, and then the children if there is no surviving spouse. So, you know, the question really is, did Ms. Moyse, does she now have a conservator or guardian who should act on her behalf as plaintiff? And the answer is yes. And that's all I would add is those pieces of case law and statutory law.
Thank you. Ms. Boughton, anything to add?
Thank you, Your Honor. I would just add that, you know, at this point, I think that it is absurd to posture that we just don't know who the proper party is. And when you reference, you know, wasting resources, I think that that's exactly what the defendants are doing here. The burden to prove incompetency rests with the party asserting incompetency, and that is certainly not the plaintiffs. So we would ask that you approve our motion to appoint Ms. Taylor as the proper party. You know, she is also serving as the conservator for the minor in this case, who is now in foster care as a result of this incident. So I think that there is certainly enough information that the court has to move forward on this motion.
Your Honor, I have just one quick response to that, and I'm just going to share my screen again because I did not go through all these when I had it up. But there are a number, I don't know if you could see this. My computer is doing something strange here, but going back, like I said, back to 2014, there was even a Gwinnett County judge. There are a lot of these cases that we pull these from. These are all in Gwinnett County where we pull these from, where there's a petition for a psychiatric evaluation filed by her own attorney in this case in September of 2014. And it came from the charges where, you know, she was charged for deprivation of her minor children. And again, it says here in this that she's previously been treated, but they're unaware of the results of ongoing treatment. So are we. We don't know whether she ever had a guardian. We don't know what the results of these forensic evaluations were. We know that like I said, in March of 2015, before this case was filed too, there was an order for mental examination. We don't know this is the outcome of that. So what the Court of Appeals was provided was whatever plaintiff's counsel provided them. We don't know what else is out there. We don't know what was provided to the probate court. And all we're saying is for this court to make, again, in April of 2015, there was an order entered for 2 different cases for her to have this, but we don't have access to these files because they're not public.
I
We can't
understand.
go in and figure out what was determined during these referrals that all predated the filing of this lawsuit. And so, no, it's not something that flip it. This is not something that's a waste of resources. This is not, there is a smoking gun here. We don't know what was fired. And all we're asking is for an opportunity for this court to be satisfied, and for us to be satisfied, we're dealing with the right party at the right time. And again, it's not an issue that's outside the plaintiff's control. They keep saying we're wasting time. Well, give us information or give it to somebody.
Okay, I'm satisfied that I've heard enough on this motion that I don't need to hear anymore. So I get your point. And basically, it sounds to me like you want me to look at it, do it in camera at least, and then make a decision. So let me look back through the issue, and certainly, that's a distinct possibility there. But we'll definitely look back at that. What is the next issue that you would like to handle? I know there's the sharing issue.
I think that's the only
scheduling.
other issue.
I'm sorry.
I believe that's the only other issue.
Okay.
And that's the defendant's motion, Your Honor. This is Teresa Benz for Skyjack, and I'll be addressing that.
Okay.
Luckily, we're not fighting here about whether or not there should be a protective order. The parties agree there should be a protective order that applies to confidential information produced in this litigation. What's at dispute here is whether there should be a sharing provision, a provision that would allow plaintiff's counsel to share confidential documents produced in this litigation with counsel in other litigation, or to use those documents if plaintiff's counsel has another case against Skyjack, OEM, or NES, the defendants in this litigation. I appreciate Mr. Penn and I were negotiating right up until this hearing to figure out if we could reach an agreement on something that would be acceptable. But the problem here is that there are unfair burdens that are created by a sharing protective order, both to the court and to the defendant's interest in protecting their documents. And there's no benefit to plaintiffs in pursuing this litigation by having a sharing protective order here. They'll still get the documents that they request if they're responsive to their requests, and also discoverable under the rules. If they aren't satisfied with what they receive from their document request, they can seek relief from this court and make that burden, but they can't do anything with a sharing protective order in this case. But it creates a lot of uncertainties and procedural hurdles. For one thing, they're saying they want to share with unknown future plaintiffs and unknown future counsel in unknown future cases. We don't know what these cases are about. There aren't any cases they currently want to share documents in, or at least Mr. Penn hasn't told me about any. So we're dealing with future cases about future defects, alleged defects, and future scissor lifts. And we don't know what those cases entail. We don't know the rules of those courts, what's going to be relevant and responsive in those cases. So for this court to say, yes, you can share that information now in those future cases, there wouldn't be the type of determination that would normally be made under the rules applicable to the forum for discovery. One case that we cited in our letter brief to this court back in November of 2018 that's informative is Porter versus Tyco Healthcare Group. It's 2008 Westlaw 11320000. At page 2, it's Northern District of Georgia, June 11th, 2008. And there the court said that, in order to enter a sharing protective order, the court would have to make a preliminary finding that the documents to be shared were relevant and responsive in these other litigations, but these other litigations are unknown and uncertain at this time. Another case, since we've made that letter, also supports that proposition. It's also a federal case in Georgia. It's Naramore versus Daimler Trucks North America LLC, and it's 2019 Westlaw 6037716, also at page 2, Middle District of Georgia, April 3rd, 2019. And it says the court must make a preliminary finding that the discovery at issue in this case is relevant to the collateral litigation contemplated by the sharing provision. That finding can't be made here when we don't even know what cases plaintiffs might choose to share these documents, these confidential documents with in the future. Sharing also opens up a universe of people who receive the confidential documents and are subject now to the jurisdiction of this court, because this court will retain jurisdiction over enforcing the provisions of this protective order even after this case goes away. Mr. Penn and I discussed this in our conferral, and he said, well, why not have the other cases? Those courts can police this order. But if those courts are going to police this order, why not have this issue arise within those courts, have those parties ask for discovery from Skyjack or OEM or NES and receive discovery responses pursuant to the rules and standards of that court, and have that court decide what's relevant, what's responsive, and what needs to be done. The Narramore case I cited previously, 2019 Westlaw 603-37716, also speaks to this issue and says the more widely confidential documents are disseminated, it becomes both more likely that those documents will be released and more difficult for the courts to enforce the terms of its protective order. So just the very fact that they're being shared affects our ability to keep them confidential and protected and protect the interests of our clients. But it also creates uncertainties about which court is enforcing these provisions, what to do if they are not abided by, who do we turn to? Will this court be addressing issues under the protective order 10 years from now because those documents are being shared? Plaintiffs' main contention for saying they need a sharing protective order is that they don't want defendants stonewalling their discovery in this case or other cases. They say that protective orders should not be entered when the effect is to frustrate and prevent legitimate discovery. And we agree, but that's not what the protective order here stands to do. The protective order without a sharing provision protects the confidentiality of defendants' documents, allows plaintiffs to use them in this lawsuit and pursue their claims within this lawsuit, and then they just have to get rid of them when this lawsuit is over. If they have another lawsuit against Skyjack, or they know someone who has another lawsuit against Skyjack, they can tell them that they made certain requests and responses were had, and that party can ask for those same documents from Skyjack. There's nothing here about sharing that will pursue the efficient resolution of this case. It will just create a lot of undue burden. There are a few things in plaintiff's letter that I just want to address, and they may no longer be relevant, but I wanted to address them. They say that we might call everything confidential, blanket all discovery under a confidentiality order. That's not the case. We've already produced 5,000 pages of documents that are not confidential, and we're not seeking to put under this order. So we're not using the order as a mechanism not to produce things. We just want to produce confidential documents in a confidential way. They also say we're not allowing the discovery of other incidents by seeking non-sharing protection, but that's not true either. Information about other incidents, if it is confidential and falls under the definition of confidential documents set forth in the proposed order, would be produced subject to that order. Once again, plaintiffs can get everything they need to pursue this case efficiently within this case, and adding a sharing protective order doesn't do anything to help that. It just creates procedural hurdles for this court, for future courts, and also risks undermining the confidentiality of defendants' documents. If plaintiffs don't believe that the documents that defendants are designating as confidential are confidential and should be subject to the order, there are mechanisms that we've agreed to within that order for them to make those challenges before this court and get those designations withdrawn if they weren't properly made. So everything that they need to pursue their case, to get the documents that they need and that are discoverable, is available to them without a sharing protective order And so we'd ask that this court enter a protective order that the parties have agreed to without the sharing provision included within it. And unless the court has additional questions.
Thank you. All right, Mr. Penn?
Thank you, Your Honor. I gone back and researched this, but I'm almost certain that you have handled or you presided over product liability cases in the past in Gwinnett County. And ultimately, at the end of the day, this comes down to the discretion of the court. And I don't know what your preference is, but I do want to touch on a couple of things. And this is what happens in product liability cases over and over and over again. You have a large manufacturer that has a very large access or a wide access to a lot of documents related to a case. This is not some cases being litigated in a vacuum. It's not a one-off. It's not some case that, it's just this one defect, this one time. There are other defect cases that are pending across the country that have been filed against this company in the past and that will be filed against this company in the future about these same issues and these same defects and what's involved in this case. And here's where the practical problem comes in. One is for a small firm, for plaintiffs' lawyers, for people who represent individuals and do not have access to the documents, it's very difficult, if not impossible, to do any research on the product and to find out what's been out there, what's gone on, and what the problems really might be because of this litigating in secrecy. And it comes up all the time in these product liability cases, probably comes up far more often in automobile product liability litigation. There's always a discussion about confidentiality orders or protective orders. And as the court may or may not be aware, oftentimes there are abuses with those. There can be abuses both ways. That is where under the shield of a protective order, a manufacturer might not produce all the documents. And one way to assure that that happens is to have a sharing provision. And that is, if there's a case pending in Chicago, Illinois, and they send a request about this product, about these kinds of defects that are involved in this case, and they get documents that are produced to them, and then I ask for the same exact information in my case, you would think I would get the identical information. Unfortunately, what we have learned through the practice for so many years in doing these kinds of cases is that's not always the case. And I'm not trying to throw any particular manufacturer under the bus, or I'm not claiming this counsel here involved in this case might do something like that. I'm just saying this is a safeguard that can be put into one of these agreements that allows for the open litigation of issues in our country, which is the default rule. All of our litigation, all of our cases that are filed in public forums, and the information is available to the public. If you file a motion for summary judgment and attach a bunch of exhibits, that is in the public and it is available to the public. And that is one method, that's one way that regulation about some of the issues that might be involved in our everyday lives. The other thing that you provide by this is the protection that a defendant in one case is going to play by the rules in the next case. And they're going to play by the rules in a different jurisdiction. They're going to play by the rules in a case in the future, and they're going to produce the stuff that's absolutely relevant. One of the things that is one of the most discussed parts of product liability litigation is just the difficulty and the secretness that is attempted in every single case. And I don't begrudge any manufacturer trying to protect legitimately confidential information, legitimate trade secrets, legitimate information that if it got in the hands of a competitor, it might do harm to their overall business. That's not what this is about. What this is about is information related to specific defects in specific cases that have been brought in public forums, and that information ought to be shared. Now, we've offered to the defendants multiple safeguards. We don't mind saying, we'll put a provision in there that says, first of all, we have to be contacted. And I'll just point out, Ms. Ben said that I haven't brought up any other cases. Well, I'll tell you this, I know of 5 or 6 other cases in the United States right now pending against Skyjack for these kinds of issues. I have had conversations with counsel in these other cases, and guess what? Most of them can't give me any information. You know why? Because they have non-sharing protective orders. So there's no way for me, without actually going and petitioning to that court, and I've actually done this one other time in my career, where I actually intervened in a case that was closed and filed a motion to intervene and to have that court produce all this information that had been filed under seal in that court. And we won. And the court released that. But some of the safeguards that we have offered to them is this. First, you have to be contacted by other counsel. Somebody has to have a case involving a scissor lift manufactured by Skyjack, and it's got to involve the same kind of issues that are involved here, where you have a malfunctioning control box and joystick that ultimately allows this scissor lift to rise inadvertently and cause a very significant injury, in this case, death. So you have to have that first. Then secondly, they have to know about your case, and they have to contact you and reach out to you. And then what we've offered to the defendants in this case is we will be happy to provide notice to them. We've been contacted. Somebody has another case. They think that we have information that might be relevant to their case. We're happy to let you know about it and give you 30 days to object to it. And you can argue whatever reason why you don't think it ought to be disclosed, or it's not something that's discoverable in the other case. And the court can rule on that and make a decision if the parties obviously can't agree to it. So we are more than willing to put safeguards in that will protect them and at least allow them to know what's going on with the information, or even what's contemplated with the information. I mean, I get it. If I'm a manufacturer and I have a bunch of information that's produced in a lawsuit, I don't necessarily want some lawyer out there just handing it out to people, or even the threat of that. And so that's why we're more than willing to have some protections like I described. And then other protections are this. You have the counsel from the other case review this protective order that's entered in this case, and they sign on to it, and they agree to abide by its terms in their litigation. So if you've got counsel in another case agreeing to abide by the confidentiality order, and the defendant has notice, and they have an opportunity to object to the sharing of that information, I don't know what other safeguards that they want other than those. And I'll just end with this. There is no question. There are some courts in Georgia that refuse to allow sharing provisions in their protective orders. I respectfully disagree with them, but for every one of those, I can cite to this court, and we cited a lot of them in our letter brief. I could probably cite 3 or 4 that actually allow and mandate sharing provisions in the protective orders. So we think we're being reasonable. Again, we have to be contacted first before any of this even becomes an issue. And we think we have the appropriate safeguards that we've offered to them. And we would just ask that we have the ability to not litigate in pure secrecy throughout this case. And that if somebody has a similar case and they want to discuss the issues, that we have the opportunity to do that. Thank you.
Thank you, Mr. Penn. Any
May I
response?
reply, Your Honor?
Yes.
Thank you. Just a few things. One point about the other cases pending. We're National Council for Skyjack, and I'm not aware of that many other cases pending, but even assuming there's 5 to 6, Mr. Penn said there's no way except going to those courts for him to find out what was disclosed in those cases. He can get the information he needs for this case by asking us in this case. And as long as it's discoverable, we have to comply with his requests. And if he has an issue with what we produce, he can go to the court. So he has the redress that he needs to get the information he needs to prosecute this case. As far as the safeguards, and we did appreciate discussing these with Mr. Penn and seeing if there was some agreement we could reach. But there still are hurdles, because what happens, which court do you go to if there is a dispute? Do we go to this one if this case is still pending, and then this court has to get involved in another case in another jurisdiction and decide what's discoverable, what's proper, what that other counsel should get to see from Skyjack's production? Or if this case is over, do we go to the other court and then that court decides? Why not just have that other court decide within the context of that litigation and have that counsel ask the questions, make the request to Skyjack? If there are documents we've produced before, because they are related to the same allegations for the same model here, control box, this should be easy to produce in that litigation as well. The presumption that we are trying not to follow the rules and not to produce documents that are responsive and comply with our court obligations underlies plaintiff's claims, but there's no basis, there's no factual basis for him making that assertion. As he even admits, he has no factual basis to make it specifically against any of the defendants in this case. Ultimately, adding the sharing provision doesn't do anything for plaintiff's case here. It creates a lot of administrative and procedural hurdles and problems and burdens. It undermines the defendant's ability to keep their trade secret and confidential documents confidential, all without, allowing for a more efficient resolution of this case, which is what discovery rules are meant to promote. So we'd ask for these reasons not to allow a sharing order if one were to be allowed. However, we would want safeguards in place, and one particular safeguard is to explain what is a same or similar defect allegation or product, because this product control box has gone through many revisions over the years, software revisions, hardware revisions, various things. And so you have to be specific about which product you're talking about. This particular control box was produced from late 2009 through 2012. So that would be the universe. And then you'd have to be specific about the allegations, because the allegations can vary, the theories of defect can vary, and that may make that documents that are responsive in some other litigation are not responsive here, or vice versa. And these are the various issues that this court would have to get into, all to allow for the pursuit of other cases, other future cases, unspecified cases, instead of the pursuit of this case, which plaintiffs have all the tools they need to pursue this case with the protective order that we asked this court enter. Thank you.
Thank you. Does anybody else have information they'd like to add in regards to the sharing order?
Your Honor, I just have two quick points I'd like to add. One is on this whole practical reality of sharing versus non-sharing, and Ms. Benz talks about all these heartaches and problems that having a sharing protective order would cause. Well, here's a very practical reality of what happens when you have a non-sharing protective order. The court, you probably already heard too much from us now. You're probably, the court doesn't want to waste its time in a bunch of hearings talking about a bunch of matters that maybe at the end of the day are not going to be really dispositive or really relevant to the underlying issues involved in this case. If there's a non-sharing provision in this protective order, one of the realities of product liability cases is defendants tend to mark everything they possibly can think of as confidential. Now, I understand there's 5,000 pages of stuff that's been been produced in this case. It's largely a bunch of owner's manuals and things that I could go out and find in the public. So I'm not talking about that kind of stuff, but other types of information that's not necessarily confidential or warrant protection there's a over designation tendency. And if we don't have a sharing provision, you're going to have the plaintiff's lawyers in this case challenging confidentiality designations constantly. And ultimately, those are going to come to the court, and you're going to have to rule, does this even warrant designating as confidential or protected? And we're going to end up spending a lot more time arguing and litigating those kinds of issues, when on the flip side, if you have a sharing provision in a protective order, that's much less likely to happen. In fact, there's not a whole lot of incentive for a plaintiff to challenge a confidentiality designation in a situation where there is a sharing provision and it provides adequate safeguards for the defendant. And I would just leave you with this. I think one of your colleagues, Judge Bratton, has a pretty famous Ford Motor Company case pending in front of him that's gotten quite a lot of press. I don't even know if that case is resolved or not. I think it's still pending. Pretty sure it is. I would be shocked to learn that there's a non-sharing provision in that case. I just would be. It would be news to me. But that's what I would leave you with. I think at the end of the day, the realities of this kind of litigation, it's complex litigation, a lot of engineering issues and other types of scientific issues are involved. It makes sense to allow protected sharing in the right kind of case. And that's this kind of case. Thank you.
Anybody else on this issue?
Your Honor, Chris Glover for plaintiff. I'll just briefly just state, it's what I do. It's what Darren does, product liability loss, really all I do. I'm sure you're familiar with the GM ignition switch case my firm was involved in. Had it not been for shared protective orders in that case, and uncovering the documents that GM withheld in litigation, and I'm not making allegations in this case, but it is not uncommon in these cases when these defendants when they have cases pending across the country to have different documents produced in different cases. And again, not making allegations against this defendants or these counsel. I've not dealt with them before, but I know it's not uncommon, and I've seen it and I've been involved in cases. These sharing provisions are specifically put in place to prevent that from happening, to keep everybody honest. And they do not, let's don't forget, the entire reason for a sharing protective order is to prevent trade secrets from getting out to competitors, people who are in the business of competing against the defendants in this case. That is the reason that the sharing provision, the protective order is even necessary to start with. And we've done everything to protect that. And the sharing provision does nothing to put that at risk. The people who will get it are other lawyers, not competitors. The other lawyers have cases against this defendant involving the same or similar issues. And I would just say that their confidentiality is completely protected while leveling the playing field between all the parties in the case.
Thank you. Anybody else? All right. In regards to the sharing order, it's nothing that is new to us. I've been issuing orders on requests like this for several years now, and I do believe that it is important for there to be sharing orders, but with very specific and narrow restrictions. So I would ask in that light that if anybody has a proposed order that they would like for me to consider, if you would email it over to Mr. Suma, and we'll take a look at those. We do have one. I have one that I used back in 2018. And I certainly can look at it and the ones that you propose and try to come up with something that meets everybody's concerns. Certainly there does need to be restrictions. It would not be a broad sharing order, but I do believe that they are important. I personally have had specific cases where, had information not been shared, that it could have been a much different result. I think both sides are asking for information here on this issue and the prior issue also of the issue on Ms. Moyes. You're both saying we don't know what we don't know. And I think that's the heart of the matter on both of those arguments. But regardless, if you have a order that you like, that you've seen, whether it's one that has been issued in a case that you're involved in, or you just know of one out there, please send it over and we'll certainly take a look at it. Is there anything else that we need to discuss today?
Not from the plaintiffs, Your Honor.
Anybody else?
This is Teresa Benz for Skyjack, and on behalf of defendants, we had raised general scheduling in our request for a status conference. And we wanted to, particularly in light of the COVID-19 crisis, kind of talk about the trajectory of the case and get your thoughts on it, and then perhaps have the parties confer to submit a discovery schedule.
I think we would need Chief Justice Melton to be on this Zoom call, and unfortunately he's not. Y'all's guess is as good as mine. I mean, the rumor is that the judicial emergency will be extended as far as jury trials go for another 30 days. I don't know when a case like this will be able to come to trial until our social distancing requirements are greatly relaxed. I mean, the sheer thought of trying to pick a jury with all these attorneys and the appropriate number of jurors that would require on a panel, just that issue alone would be difficult. At this point, I don't think that we can really make any plans. I think it's going to be a little while down the road before we can make any really specific plans. We could go ahead and look at a scheduling order to maybe go up to let's just wait. I think that's the best thing. Let's just wait. I was going to say we could do part of it, but I think right now we just need to wait on a little bit more direction from Justice Melton and have a little bit better idea. Yes.
Your Honor, Jimmy Singer, I just wanted to, I think really what we wanted to point out to the court, because this case has, as Darren indicated, been pending for so long. No party has yet been deposed. Document production is not yet complete. There are some fact witnesses that have been in different places that haven't been deposed. So we are months away from concluding discovery, and then there's going to be motions for sure in this kind of a case. So we wanted to just alert the court, because it had appeared on the prior trial calendar, that despite the passage of time and the length that the case has been pending, we're still some distance away from being in a position to do that. We just wanted the court to be aware of that.
Well, and hopefully this delay in jury proceedings will give you the time needed to get ready. I mean, certainly y'all understand the way calendars work in any judge's office. We put them on according to date. And yours is a 16 case, and I don't have many 16 cases left. So it may go on a calendar. It doesn't mean it can't be taken off or removed or continued. And we certainly can work on a scheduling order so that you have deadlines on getting all those things taken care of. But I think at this point, it's something we'd rather hold off on temporarily and get a little more education about when it could be tried. And again, we can look at all those deadlines you're speaking of and try to help with those, but I'd rather wait at this point. Okay, anything else?
No, Your Honor.
Our court reporter has a question. Hold on.
Am I understanding that I'm sending a takedown bill to Mr. McLaughlin?
Mr. McLaughlin, she's asking if the takedown bill is supposed to be sent to you.
As the only defendant, if you want to send it to me, I can distribute it among the defendants to be split up if you like. That's fine.
Or was it Mr. Singer that said?
Yeah, it was Mr. Singer.
Okay, very good. My arrow wasn't quite on the spot. Thank you.
Feel free to send it to Mr. McLaughlin if you want to. You know.
Appreciate that, Jimmy. Thank you.
All right, anything else?
No, Your Honor.
No, Your Honor.
Okay. Thank you all for being patient and working through any of the technology challenges that we may have had today. And we'll certainly work with you on getting this case ready for trial whenever that trial may be, and certainly work with you on getting a scheduling order together so that we can ensure everything is taken care of. But I appreciate your patience again. I wish you all health and sanity during this difficult time. And I wish you much internet knowledge so that you can go forward and practice law without being in a courtroom. So thank you.
Thank you. Your Honor.
Thank you. Appreciate it.